the Civil Procedure Act. So they are not bound by it. And therefore, if you do that, you are risking your marks, and you're giving the examiner the discretion either to give you the marks or to deny you the marks. Okay. And as I've told you all along, that when you're doing an exam and you're answering a question, for every right question, so for every right point that you make, you get a point. Okay. But for every wrong answer you make, you lose a point. So if in this instance, you mention the 3 orders of judicial review, okay, essentially you're supposed to get 3, assuming that 3 marks, you're supposed to get the 3 marks. But if you go ahead and mention other orders that are not part of judicial review prayers under section 8 and 9, then the examiner will have the discretion either to mark you down or to leave your marks as that. So you don't want to give that opportunity to an examiner to decide whether to give you the marks or not, depending on who they are, because some of these people are not if the person marking your paper is a constitutional lawyer, then they will be able to understand why you have it like that. But if they're not constitutional lawyer and they are strict practitioners, then they will not be giving you the mark. So you don't want to go to that extent. There's certain things that you can get away with in practice. You know, there's certain things you can get away with in practice. For instance, you can make an application for habeas corpus through a petition. You can do that in practice. You'll get your orders, you get your prayers. You can make it through even originating summon. You will still get your order, but you don't do that when it comes to an exam. So certain things, just in as much as yes, they make legal sense and they have some backing in the constitution, but in as far as you answering an exam is concerned, try to be strict to the books. Are we together?
Yes, very well.
All right, so I want us to start and not really start, and I mean, the class is being recorded, as you can see. So please take care of your privacy as we begin the class. So today is Tuesday, the 22nd of October, 2024. We're exactly around a month and a half to the end of the year. All right, so in the last class, we talked about sentences, and for you to understand sentences, again, you know the rule. The rule is we need to understand how we go to sentences. So could somebody explain to us? I want 2 people. The first person will explain to us the criminal procedure up to sentences, and then the second person will explain to us the trial process. What is the trial process? The reason why I keep saying that is because I know that exam questions are set based on the stages. You are not able to understand a question on plea versus a question on sentences unless you know it is a question on plea or a question on sentence. So it is very important for you to understand that procedure, and that is why we keep doing it. So somebody kindly give us the criminal procedure right from the very beginning to the very end, quickly. Somebody, and somebody mute your microphone, please. Somebody is having the microphone on and it should be muted. Somebody. Yes, Anyanzo, let's go.
Okay, on the criminal procedure, it starts from when a complaint is made at is reported at the police station. Once a complaint is received, the next step is taken is investigation, whereby investigation involves the creation of the police file. The police file, the creation includes the gathering of information and evidence that relates to the complaint that was received. Investigation also includes may include the arresting of the suspect, as well as an ID parade that is to be conducted. Once the investigation and the police file has been prepared, the police file and its contents are then handed over to the Director of Public Prosecution, who is vested with the powers according to Article 157 to make the decision to charge. Once the decision to charge is settled on, the next step is when the arrested person is arraigned in court. Once they're arraigned in court, there are three scenarios that are presented. One scenario is whereby the arrested person is released. Second scenario is where the charges are read out to the arrested person, and the third scenario is whereby the court gives an order that detention continues, stating the reasons as to why the arrested person will remain in detention. After that, then the next point becomes where the charges are read out.
We've lost you. We have lost you. We have lost you, Anyanza. Can you hear us? Can you hear us? All right, she's dropped out. Somebody to pick up from there. Somebody quickly. Somebody pick up from there. Okay, guys, is it that we are not? You don't understand what I'm saying or what? Guys, could somebody pick from where she's left? Anybody to pick from where she's left? Okay. Guys, can you hear me?
I hear you, Mwalimu.
Can the rest hear me?
Yes, we can.
Kimotho William. Proceed from where she's left. Kimotho. Can you hear me, Kimotho? Is it my network? Surely. All right. Simiyu John.
Yes, I can pick up from where the previous speaker was. So once the charges have been read out to the accused person in a language which the accused person understands, then the accused person has options of either entering a plea of guilty, plea of not guilty, out of acquit, out of convict. And also at this stage is where we have the bail.
What is the last plea?
Yes.
What is the last plea? There are 5. You mentioned 4. What is the last one?
The last one. It has escaped my mind.
What is the last plea?
Okay.
All right. Anyway, proceed.
Okay. Also, at this point is where we have the bail, where the accused person can put in their bail application.
We don't have bail during plea. Can you proceed procedurally? You're discussing plea. And your network is your volume or there's an echo from your end. We can't hear you clearly. Something wrong with the network. Anyway, somebody else, someone else. Someone. Guys, are we saying that we don't know this thing or I should just proceed? Which one is which? I want answers on either. We don't know or should I just proceed? Quick answers. We don't know or I should just proceed.
Mwalimu, no.
I'm talking to the rest of the people that don't have their hands up. What is happening? Uh-huh. Should I just proceed or you guys don't have an idea of what this thing is? I'm waiting for the response. What is the deal? I have time. Guys, what's happening? Should we proceed? Okay, so I think I'll proceed as if you don't hear me. Let me just proceed as if I can't be heard. So I'll just speak until the very end and then we'll just go home. So in the last class, we talked about sentences and we said that sentences come as a result of punishment um, that has been meted against the accused person for the conviction. We said it must come from a conviction. So once the conviction is there, then the court sits down and determine the sentence, which is the punishment that is supposed to be given to this specific person for the commission of the offense. We say that judgment will come in two forms. The first form of judgment is what you're calling a conviction. This is where the accused person has been convicted that they committed whatever they're being accused of committing. That is a conviction. And then after the conviction, then the court proceeds to set up the matter for sentence. That is the sentence hearing. Now, the sentence hearing, the court is setting down itself to determine, based on the conviction, what is the relevant punishment that should be given in that instance. What is the proportional punishment that this person is supposed to get for the commission of the offense that they have committed? Now, in that class, we talked about Section 24 of the Penal Code, where we say that all the sentences must be legal in the sense that they must be provided for within the law. Now, if you went through the question to do with the sentences under Section 24, we mentioned all the sentences starting from death penalty all the way down to the rehabilitation centers, and those are the punishments that you will get in all the instances that you've been convicted. And we also said that in a question, just like the questions we saw in the last class, when you are told to discuss various options available to the judge or the various sentences available to the judge, then you don't just go mentioning sentences. You have to mention the applicable sentences. Okay. For instance, there are certain sentences that you cannot get life imprisonment. There's certain offenses that you could get a life imprisonment. There are certain offenses you cannot get death penalty. Okay, there are certain offenses where custodial sentence is secondary, not primary. So you need to understand what is the offense in question, who is the accused person in question, and then you then look at the available sentences. Because if you advise the court, for instance, in that case, to produce or to declare a sentence of death penalty where the accused person is a minor, then that becomes the miscarriage of that translates to miscarriage of justice, and of course that specific decision will be challenged either on appeal or on revision. Okay, so that is the question of sentences. Now we went and talked about the principles informing sentences, the principles of sentencing or the sentencing principles. Now these are the aspects surrounding the reasons why there should be a sentence. Okay, we talked about the various aspects. Surrounding the sentences in terms of why do we punish. Okay, so for you to understand what a principle of sentence is, then you need to ask yourself the question of what is the theory around punishment? Do we need to punish the offenders? Okay, and in punishing these offenders, what are some of the guidelines that we have to follow? And that is the question of proportionality, equality, accountability. We talked about such in the last class. That is the principles of sentences. Now, the third thing that we talked about in the last class is the objectives of sentences and the objectives of the sentencing and policy guidelines. Now we have something called the sentencing and policy guidelines. Now these guidelines are the ones that governs the court or guides the court in trying to reach a specific sentence, so that if the court is going to settle down on a sentence, the court must consider the sentencing policy guidelines. Now, these guidelines have got their own objective. They have an objective. There is a reason why the guideline is there. Now, the question, just like we saw in 2021 November, question 6, question 5, where you are told to discuss the relevance and the objectives of the sentencing policy guidelines. So in that instance, we are not looking for the objectives of sentences. We are looking for the objectives of the sentencing guidelines. So please make sure you know the difference. When it comes to the sentence, the objectives of the sentencing, then we are talking about the question of deterrence, restitution, and all that. The reasons why we are punishing, the objectives of punishing. However, we also have the objectives of the policy guidelines. Why do we have the policy guidelines? Why specifically do we have this document we are calling the sentencing policy guidelines? So what objective is it trying to achieve? That is exactly what we looked at in the last class. Now, I also introduced the case of Francis Kariuki Muratetu. Now, in this case, if you remember very well, I gave you just a brief introduction or a brief history of how Muratetu came to be. And I said that Muratetu was a murder case against the sixth accused person that went all the way to the Supreme Court. However, I also mentioned that before this matter went to the Supreme Court, it was at the Court of Appeal, because it ended at the Court of Appeal. And like we said in the last class, the Court of Appeal is the court of last resort. In terms of criminal matters, the Court of Appeal is the court of last resort. Even in civil, the Court of Appeal is the last court. However, if there is a matter that is touching on the constitutionality or the applicability and interpretation of the Constitution, then it can be certified and then sent to the Supreme Court. So it can only go to the Supreme Court if it meets the test under Article 164, which is the question to do with, 163, which is the question to do with, it is a matter of great public importance and one that touches on the applicability and interpretation of the Constitution. Okay. Now, Muratetu went to the Supreme Court, and the Supreme Court declared Section 204 of the Penal Code, which is the mandatory nature of death penalty, unconstitutional. So the Supreme Court said that that specific section was unconstitutional to the extent that it made death penalty a mandatory sentence. And the reasoning is that mandatory sentences, or what we call the minimum sentences, always negate the question of judicial discretion, so that the court is not even supposed to look at the factors under which the offense was committed. The court is simply supposed to look at the actual commission of the offense. Okay, so that the court said that was unconstitutional, and therefore the court directed that the same be resentenced again, that the matters be resentenced again, and therefore that was Muratetu. So in the same instance, the court gave now what are some of the instances, what are some of the factors that the court needs to rely on when they're delivering their sentence. And then there's Muratetu 1 and Muratetu 2. So my hope and prayer is that at this moment, you have taken your time and you've gone through both. Okay, so that was our class in the last class. Now, the next thing that I also mentioned in the last class is that we have something called the sentence hearing. The sentencing hearing. Now, the sentencing hearing is a hearing that is conducted specifically for sentences. Okay? Specifically to decide on the appropriate sentence. You only participate in that hearing if you are trying to sway the court or convince the court to arrive at a specific sentence. That is what you call the sentence hearing. Are we together? That is the sentence hearing. Now, at the sentence hearing, certain things happen. At the sentence hearing, certain things will happen. Okay? Now, I've said that you guys don't want to speak today, so it means that I will speak like a mad person today. Speak to myself. I will answer myself.
We are hearing.
Mute that microphone. Let me not hear anyone speaking in this class today. If I hear even a voice, I throw you out. Nobody is supposed to speak in this class today. I will ask all the questions and I will answer them. I can multitask very, very well. All right, so like I was mentioning, and that we have a sentence hearing. So the next thing we need to look at is now who participates in the sentence hearing? Who participates in the sentence hearing? This thing you're calling the sentencing hearing, who is supposed to participate in it? The first person, of course, is the court. The court must participate. The court will always participate. The prosecution, the accused person, the victims, okay? And then we have, of course, the children officers, if there's a matter that affects the children. And then we have the witness protection agencies, agencies. I'm together. Now, the reason why I'm bringing this is because certain questions you will be told directly to name or discuss at least 5 parties or some of the parties that will participate in the sentence hearing. So at that moment, the court, of course, must always participate because the court is the one meeting the sentence. At the same time, the accused person and the prosecution. Then we have the victim. And I've given you the case on victim. I've given you the case on victims, which of course you do remember. The case on victims and the participation of the victim in terms of a criminal process and all that. The Victims Protections Act that we went through from section 4.9 all the way to 26 in terms of what are the rights of the victim. At the same time, what are the limits of the victim's participation in a criminal trial. So the victim must always participate. The victim must participate. Together. That is very, very important. And Joseph Lindex Waswa explains that case very well. Paragraph 74, that case of the Supreme Court decision is the one that talks about the participation of victims. Okay, I hope that makes sense. I hope that clarifies the point, and make sure you read that case because I've always talked about that case And I've said you read it at all time, participation of victims. All right. Now, once that is clear, let us look at what is happening during a sentence hearing. Now, at the sentence hearing, then the first thing that is there is the question of aggravation. The second thing that is there is the question of mitigation, and then the court will go to the third thing, which is the victim impact statements, the victim impact statement and assessment, and then the court will pass the sentences. That is the punishment suitable for that specific offense. Okay, so let us start with the first one, which is aggravation. Let us start with the question of aggravation. Now, remember, at the sentence hearing, it is a hearing. Okay, this is a sentence hearing. It is a hearing. Now, because it is a hearing, every party will have the right, okay? Every party will have the right to support their part or to support their side of the story. Every party will have the right to support their side of the story. Okay? Now, what is the interest of the prosecution? What is the interest of the prosecution? The interest of the prosecution is to have the accused person sent to jail. The interest of the prosecution is to have this accused person sent to jail. That is the interest of the prosecution. And therefore, how do they do that? By aggravating the sentence, by telling the court, this person has been found guilty of doing this and this and this and this. Please consider the maximum punishment for this person. That is aggravation. They are aggravating. Okay? The interest of the accused person is to get a lesser sentence. The accused person would want to have a lesser sentence. Okay? And therefore, because you want to have a lesser sentence, then you tell the court the reasons why the court should be lenient on you. You will tell the court that, oh, I'm the only child in my father's house. I'm the one, I'm the breadwinner. I'm a first offender. Oh, I'm sick. I was provoked. I was drunk. All those things, the reasons that will make the court to have some mercy on you or some leniency. That is what we're calling the mitigating factors. So the prosecution will always have the aggravating factors. These are factors to show that this person deserve the most serious or the most severe punishment. Okay? So that is the question of aggravating circumstances. It is the aggravating circumstances. So you aggravate. That is what happens first. The second thing is a mitigation. So what are the mitigating factors? And you'll be given a question, guys. You'll be given a question, and from the question, you will be told to proceed and deduce the aggravating factors that you as the DPP will put forth, or you will be told that these are the facts. Please give us the mitigating factors that you as the accused person's advocate will put forth. So it is upon you to know and realize which points are those. Now, the first thing I've said, that aggravating factors are factors that will convince the court to give a stiffer punishment, a more severe punishment. Okay? For instance, if the maximum prison term is 30 years, then the aggravating factor, remember the court is open to giving 1 year to 30 years, if that is the sentence, 1 year to 30 years. But now the aggravating factors will convince the court to give 30. Okay? The mitigating factors will convince the court to give 1. So mitigating, lesser sentence, and aggravating, stiffer sentences. All right, so what are some of the aggravating factors? What are some of these aggravating factors or circumstances that will make the court to give or to pass a more stiffer sentence? The first one is use of a weapon to frighten or to injure the victim. Okay, that is what you need to understand, the use of a weapon. The use of a weapon. So if you use a weapon while committing the offense, then that is an aggravating factor. So we are going to say that, Your Honor, this person did not just come to steal. or he didn't come to pick this thing. He actually used force, and he had a gun, he had a knife. That is a weapon. So the fact that you had a weapon makes it so serious that you should get the maximum punishment available under the law. That is the first one. Okay. The second one is the question of the number of your victims. How many people did you affect? How many people did you injure? Did you assault 10 people? Did you kill 30 people? Did you steal from multiple victims? So we look at the number of victims. The more the number, the harsher the punishment. That is the question to do with the number of victims. So we look at your victims. If you have multiple victims, you are on a rampage, assaulting people everywhere, then that will be an aggravating factor. It makes your punishment more serious, okay? Because you had a lot of victims. So please make sure you understand that point as well. Now the next one is the impact on national security. This offense that you have committed, how does it affect national security? Okay, the offenses such as the offense of terrorism is a one that really affects national security, and therefore if you have been convicted of terrorism or a terrorism related offense, then you are in for a stiffer punishment. So we look at the question: is this offense one that is against national security? Okay, and then of course the serious physical, psychological effects on the victim. This offense that you committed, what harm has it caused on the victim? It could be a physical harm. You've broken their leg permanently, or given them a disability, or you've tortured them mentally. For instance, if it is a sexual offense, of course, that has a lasting emotional and psychological consequences. And therefore, if that is the case, then you are standing in to see a stiffer punishment sent your way. Okay, so that is the question of the effect on the victim. Number 5 is the continued assault on the victim. So, did you just strike once? Did you just strike once, or you kept on striking? And of course, the case of Miss Langata prison, the lady that killed, I don't know whether that was a husband or a boyfriend or whichever person that was. And of course, the evidence availed before the court revealed that this lady stabbed that man 25 times. If you stab this person once and they died, then you could get up to life imprisonment, or even 20 years or 30 years or such. But if you stab this person 25 times, like the report said, then you are in for a serious offense. And of course, she was sentenced to death, and she's still serving the life imprisonment at Langata. Of course, after the after commuting that to life imprisonment. So if you stab this person, or if you assault this person repeatedly, or if you shot this person maybe 30 bullets, for instance, that is a lot. That is a repeated assault. And therefore, if there's evidence that you repeatedly assaulted this person, you kept beating them up even after they collapsed, that is a serious evidence to warrant a more stiffer punishment. We have the question of a gang. If you committed this offense in a group or in a gang, then of course that is a serious offense. If you read section 295 and 296(2) of the Penal Code that talks about robbery with violence, one of the things that makes robbery with violence so serious is the fact that you were in the company of another person. By the fact that you committed that offense in the company of another person makes it serious. Okay, and therefore, if there's evidence that this offense that you committed was committed either in a group or in a gang, then that is a serious offense. Gang rape is so serious, then you get serious punishment as opposed to as compared to actual rape. Okay, so committing an offense in a group or in a gang is a serious offense, and therefore you will get a more severe punishment. Okay. The other one is the question to do with targeting the vulnerable people in the society. Okay. So this is an offense against children, an offense against the elderly, or an offense against the person of, people with disability. That is a factor to warrant a serious punishment. Though courts have added women in the list, courts have added women in the list so that if there's an offense against, of course, women, to some extent, women are vulnerable. And of course, the results or the statistics show that women are more prone to these offenses, violence and assault and all that, as compared to men. So that makes women more vulnerable. And therefore, if there's evidence that you committed an offense against not just children, elderly person, or person with disability, but also women, then that is a serious offense. And remember, we talked about the question of the objectives of sentencing. Why do we sentence somebody? We sentence someone so that we can send out a strong message and a strong act of deterrence that we don't entertain this kind of offenses. Okay. Now you understand the society that we've been. It has evolved. We can say it has evolved. But even in that evolution, we still have problems. We still have cases of femicide and all that. You remember, I think even today in the news, there's still cases of women disappearing and being found dead somewhere. It's a bad thing, and therefore even the law has evolved to make it a serious offense or an aggravating factor that the offense that was committed against the vulnerable members of the society, which of course include women, children, persons of the old age, and people with disability. That in itself is, if you commit that offense, even the judge or the magistrate will be looking at you as the agent of the devil. So you don't deserve any mercy. Okay, you go straight to jail. All right. The next one is a previous conviction or a pattern of commission of that offense. If there's a pattern that this offense that you've committed, you actually committed it previously. So you've developed you're a vagabond. You've developed a pattern of committing the same offense. You assaulted somebody in 2012, you went to jail, you came out of jail and you still did the same offense. And that in itself is an aggravating factor, telling the court that, hey, this person is a repeat offender. Okay, is a repeat offender. Remember that the opposite of that is a mitigating factor. So the prosecution will argue this person is a repeat offender and therefore he should get the maximum sentence available. Now the accused person may argue that I am a first offender. First offenders usually get the lenient or a less stiff offense. Okay, so if you're the first offender, of course, the court might have some mercy on you. But if you are a repeat offender, then of course you are going to meet the full force of the law. And then, of course, the question of intricate planning of offense. If this offense involves some serious planning, resources, and time, then that is the question. It talks to the mental. It talks to your mental, the guilty mind, the men's thread, that you sat for 10 months or for 1 year just plotting this offense, or you sat for weeks and months plotting how to commit this offense, then that in itself speaks to the guilty mind, and therefore the court will not have mercy on you, because we expect that at some point, when you commit an offense out of provocation, it means you did not plan to do that offense. You're just provoked to do it. Therefore, that is a mitigating factor. However, if you commit an offense that you actually planned, you recruited people, you bought things, then that in itself is an aggravating factor that will warrant some serious punishment on you. And then, of course, an intention to commit a more serious offense than that was which was actually committed. So if instead of committing a serious offense, you committed a lesser offense, you wanted to kill this person, but they survived, and therefore it could be grievous assault. You shot them at the head, or you stabbed them 30 times, because that is an indication that you wanted to kill them. But if they survive and you are now charged with a grievous assault, then you will get the serious or the most the stiffest, if there's something like that, the stiffest punishment or sentence, because we know that you actually wanted to commit murder. It is only that you are not able to commit that murder, and therefore you committed grievous assault. So if there's an intention that you wanted to commit a serious offense, then that in itself is a is is an offense. That in itself is an offense. And therefore, you will get the stiffer or the stiffest of that offense. And then, of course, the high level of profit from the offense, if it's an offense that involves money or some pecuniary benefits, if you're the person that is benefiting most from that offense, then you get the serious punishment. Okay, we have the use of violence or damage of property. You used violence when committing that offense, or you damage property while committing that offense. That is self-explanatory as well. The question of concealing evidence, that you actually concealed evidence, even through the trial, you are not honest to the court. Okay, so that in itself is also a question of is an aggravating factor, and always will of course attract a stiffer punishment. Abuse of position of trust and power, if this offense was committed by you as a public officer, uh, of course, in the abuse of your power, or you took advantage of your of your position of power, your office, to influence, for instance, corruption. You use your power or the authority as maybe the accountant to divert funds, or the principal secretary to do something, then that abuse of power becomes an aggravating factor. And then, of course, targeting those working in the public sector or providing a service to the public. Okay, this is a serious offense. There's some of you that think that they're very strong, and therefore they can beat the police. Don't be cheated. Don't try. That is like committing murder. Don't beat members of the forces, either disciplined forces or the ordinary police people, or generally any person that is acting under the direction of the public or providing services to the public. They could be employees of the government. At that moment, you are beating them up or assaulting them. They are employees of the government. Or they could be police officers, okay, under the direction, of course, of the Inspector General of Police to administer their functions, and you beat them up, You beat a police officer, of course, my fans, they'll be happy. They'll say, oh, you're a brave person, you're a strong man. Wow. And then you go to committee. In addition to going to committee, of course, these police people will be looking for you, and most definitely they will want to kill you. And you've seen even instances where people have assaulted police officers. Even the court will not give you bail. The court will not give you bail. And the reason why the court cannot give you bail if you've assaulted a police officer is because your life is in danger. They know very well, even the law, the judges know that in that offense, your life is in danger, and therefore you are safer in police custody, because they will not kill you in custody than when you are roaming on the streets. They will just kill you, and then so it is very, very serious. So avoid abusing or targeting people that are in the public sector. If you feel you're too strong that you can fight, look for your fellow friend and go beat each other, and then die. Whoever is dying or whoever is surviving, let them survive. But don't fight those in the public sector. Don't assault them. Don't harass them. Don't obstruct them. Don't kill them. Don't steal from them, and all that. It is a serious, serious aggravating factor. And then use of grossly inhuman and degrading means of committing the offense. If you committed that offense in a very degrading manner, for instance, even murder, how did you kill this person? if you tie their leg this side and the other leg that side, and you have two moving vehicles in the opposite direction, that is grossly inhumane. So even though you're being charged with murder and you're guilty of murder, one person guilty of murder can get 30 years or life imprisonment, but for you, because you've committed that offense using a grossly inhuman and a degrading means, you will get the maximum punishment, which is death penalty. And of course, commission of offense motivated by ethnic, racial, or gender bias. That is a serious offense as well. If you beat up your neighbor just because they're coming from a tribe that you don't roll with, you don't like that tribe, or you don't like their race, or if it is a gender-based violence. This is also something that the courts have pronounced themselves on every single time. The courts have said that they're not willing to bargain with the terrorists, more so people that commit gender-based violence. Okay, so if you are an advocate and your client has been accused of committing a gender-based violence, you need to advise them to start making friends at committee, because there's only one way that ends. They're going to jail, because that is the only way that the society or the courts can keep the society safe, by making sure that we are sending a clear warning that we do not accept gender-based violence in any form, shape, or manner. And if you commit a gender-based violence, of course, that is aggravating factor. So if that evidence comes up that the offense that you committed was actually gender-based, or it was based on the gender of the person, then of course, your place is in committee, where there's only one single gender. Okay, if you don't like to live peacefully with the other gender, then there's a place where there's only one single gender, that is committee. You will be taken there and you live there peacefully with your gender. Okay, and you'll now become their other gender. That is how sad it is. So if you assault people here, commit gender-based violence here in public, I mean peacefully at home, everywhere where you can still do other things, then the law will say, okay, you don't like the other gender. Now we take it to a place where there's only one gender, which is on Committee Road. That is Committee Maximum, or Naivasha, or Manyani, or Shimolatewa. Those places have only one gender. So if you don't want to live peacefully with this other gender, that is the place you're going to. And the moment you get there, you now become that other gender now to them. So please, be peaceful. Don't commit gender-based violence, because the punishment is very, very severe. Okay? But remember, the opposite is also a mitigating factor. If you commit a gender-based violence, or if you commit an offense in response to gender-based violence, it is a mitigating factor. That is a mitigating factor. So guys, these are the aggravating factors. The prosecution will avail these factors. They are availed by the prosecution. Now, don't guess. Sometimes the question can ask you to discuss some of the mitigating factors or some of the aggravating factors that you can put forth at the sentence hearing. General question. Or sometimes you can get a question asking you to discuss some of the mitigating factors or the aggravating factors from the set of questions that have been provided for in the facts. So go to the facts and look at these factors. Was it a gender-based violence? Was there a use of weapons? Were they many people? And all that. Are we together? So make sure you understand the aggravating factors and who brings forth the aggravating factors, which is the prosecution. All right. Now let us go to the opposite of aggravating factors, which is now the role of the accused. The accused person has the right at any time to mitigate. And the reason why we are mitigating as per Muratetu, and of course, that is to try and tap into the court's discretion that the court is supposed to consider before the court can pass a sentence. The court, through the judicial discretion, is supposed to look at the circumstances surrounding the commission of the offense. Because if we were saying that once you're convicted, we give you the maximum sentence, then that will not make sense. Therefore, we need to give time and consider, yes, you committed this offense. Under what circumstance did you commit? Did you commit this offense? Okay, so you'll be in court and you'll see somebody accused of manslaughter getting sentenced to, let's say, 2 years in prison or 1 year in prison. Or sometimes I've been in court where somebody accused of manslaughter has been convicted, found guilty of manslaughter, but sentenced to 6 months of community service. So the court will look at the circumstances surrounding the commission of that offense. Yes, you committed the offense. Okay, the fact that you committed murder doesn't mean that you need to go and suffer death. No, we look at why did you commit murder. The first one, if you look at Rule 23.8, mitigating circumstances warrant a more lenient penalty than would ordinarily be imposed in their absence. And they include, number one, the question of a great degree of provocation. The great degree of provocation. Okay, so that means that you are really provoked. When you committed that offense, you are really and seriously provoked. So provocation is a mitigating factor. And of course, provocation as well is a defense. So that is a mitigating factor. The fact that you are provoked, now that I've mentioned it, before I forget about it, go and look at some of the defenses in law. I'm not saying they're going to set it. I'm just saying that this is a topic that you ordinarily undertake in your undergraduate, similar to the Evidence Act or the law of evidence. Nobody will teach you those two things in the Kenya School of Law. Nobody, but they will gladly set it. They will set it without thinking twice. So, two things. Always, as you prepare for this exam, specifically make sure that you are in the good books of two things. The first one is the general principles of criminal law. Number two is the evidence law. The production of evidence more so in criminal matters, corroboration, confessions, admission, documentary evidence, and all that. Please make sure you understand that. Make sure you understand that, because nobody will teach them, but they will be coming. So, great degree of provocation. That is the first one. That is the first offense, that you committed this offense because you were provoked. Something they said, something they did, or something you found them doing. And therefore, you committed that offense not because you premeditated, but you were provoked into doing that offense. That is the first one. The second one is commitment to repairing the harm caused by the offender's conduct. Okay? So you've decided that you've changed. You've committed that whatever you stole, you will give it back. Whatever the assault that you committed, you will compensate. You pay the hospital bills of the victim, you compensate them, and you've reached out to them, and you guys have reached a conciliation. Okay? That is something that is an a mitigating factor, that even before the sentence or before the conviction, you already agreed with the witness, not the witness, but with the complainant or the victim, that you are settling that matter out of court. And actually, you already paid back what you owed them. So that is a mitigating factor. It gives the court an opportunity to show you some kind of mercy. Okay, and then we have number three, the negligible harm or damage caused, that you didn't cause a serious offense. So remember that the nature of the assault, the seriousness of the assault or the harm or the damage that you caused will fall under aggravating factor. The opposite will fall under mitigating factor. So if the harm or the damage that you caused was so severe on the victim, then that is an aggravating factor. But if the damage or the assault or the harm that was caused is negligible, then of course that is a mitigating factor. And then, of course, we have mental illness or impaired functioning of the mind. When you committed this offense, you had some impaired functioning. Your mind was not functioning clearly, and all that. Okay, you know the rules when it comes to insanity. So look at again insanity as a defense and also as an a mitigating factor. Age, okay, where it affects the responsibility of the individual offender. So if you are, let's say, 80 years, or of course we've seen in Nakuru where a lady that was 87 years of age was actually found guilty of robbery with violence. So you wonder how this 87-year-old lady in Nakuru committed this offense. But anyway, so age is a question. So if you are too young, for instance, if you're below the age of, should be below the age of 12, you're not able to form criminal liability or capability of doing committing any offense. And then, of course, if you're too old as well, we know that we are supposed to be lenient. Again, you know that when it comes to children below the age of 18, of course, there's no child above the age of 18, but any person that's below the age of 18 is supposed to get some leniency because they're children, and therefore they don't get the maximum sentence. And those two sentences, those two words are crazy. You know where I come from. Every day you pray that S and H don't follow each other. That is the only trouble we have. You know, as a community, our only trouble is we only have two prayers. Our first prayer is that S and H doesn't follow each other. That is the biggest. Second prayer is that we are praying that, of course, we know we are going to win the AU, and then we will not be interested in whatever is happening in that country. You know, right now you're saying, oh, some of you have been fired from the office of the deputy president. We're just watching and laughing because we know next year all of us we are going to Ethiopia. That is where our offices will be. So those are our two prayers, the main prayers. You know, those are our main prayers. So S and H, that is the biggest one. You know, other communities have been given like punishment, you know, like we know the people from the mountain, your first punishment, apart from the R and the L, was the forehead. So forehead is your biggest undoing. So as you carry the big forehead, there's also R and L. You have a lot of trouble as a community, okay, that you need to address. For us, it is just S and H.
Easy on the help.
As we look for fare to go and occupy the AU offices. Saa hii siasa ya domestic tumewaachia Wakikuyu na Wakale wapigane who will be the deputy president. Sisi tunaenda AU. All right, so that is mitigating factors. So age is very, very important. So if your age is below the age of 18, of course, you know you need to get a lesser sentence. If you have I mean, if you're above the age of, could be 80, or it's essentially you're considered an elder or a senior member of the society, also the court is supposed to be lenient so that you don't die in prison. When you get to the age of 80, you're just approaching your death. So it is not wise that you're sent to jail and then you die there. It is not advisable. So that is why we have preferential treatments when it comes to people that are old and people that are young. So if you're too young, we don't send you to prison as a matter of fact. And also if you're too old, but in certain instances, depending on the offense that you commit, there are certain offenses that you commit them, there's only one place you can end. That is prison. So please make sure you understand that also as well. So number 6 is when you play a minor role in the offense, that is also a factor. So if you committed that offense in a group, but for you, your offense was to facilitate their transport. transportation from point A to point B, then that in itself is a minor role. So therefore you get lesser punishment. Being remorseful. If you are remorseful, you go to court and you plead with the court and you ask the court for forgiveness, you ask the victims for forgiveness, then the court will, of course, have some mercy on you. And then we have being a first offender. I already mentioned that. If you're a first offender, of course, the court will say, okay, you need to, we need to give you just a warning and all that. Okay. And then number 9 is very, very important. Number 9 is commission of a crime in response to gender-based violence. Like I've already said, that we as a country, we are coming from the dark days where even look at our laws, how they were enacted. Okay, there's a way they were enacted that gave men some kind of advantage over women, and that of course gave rise to gender-based violence and all that. Now the current system, we are trying to move away from that, and we are trying to shun certain conduct or certain practices that are deemed as demeaning and as violence against women, the female children, as well as children. So if you commit an offense that is that is facilitated by gender-based violence, that is a serious offense, and therefore you will get the most serious punishment. But if you commit an offense just because you are responding to gender-based violence, it is an aggravating factor. And of course, you know that case in is it Kakamega or Vihiga, one of these Shamakoko, Shiveve, those counties. Justice Aburili delivered a judgment 2 years ago, and of course that has given us what we call the defense of a battered woman. The defense of a battered woman, as per that case, is, remember, the woman that killed the husband, and the sole reason why she killed the husband was because the husband was, of course, assaulting her every day, and that day was just a bad day in the office, and she killed the husband before the husband could kill her. So in that case, the lady was convicted to the offense of murder, and she was sentenced to 1 day in prison. She actually didn't spend a day in prison after that sentence because she had been in custody at some point. So based on that, the court clearly said that as a society that is moving away from gender-based violence, more so from the male gender, we need to send a clear message that we do not entertain any form of violence against women generally, but also we have women that are also assaulting men. I don't know about other communities, but also where I come from, we've had instances where there are women that are very strong. Luo women are very strong. They can beat you like a dog. So they can always assault you. So even in that instance, the law says that any person who commits an offense against another person just because of that gender, if you beat a man, that is gender-based violence, and you're going to Langata. There's a very huge prison in Langata, specifically for strong women. The only place where strong women in that country are taken is Langata. So if you're a strong woman, strong and independent, yes, Langata prison is your place. If you beat a lady, there are so many places from Kisumu to Mombasa. There are so many prisons for men, so you can go there. So don't commit any offense against any gender. I think even right now, I think there's still communities. I don't know whether the Western Kenyan social community is still doing it. We have wrestling for men. You can go and fight your fellow man. If you feel like you want to fight, go and fight your fellow man. Nobody will come and arrest you because that is a sport for you. But don't extend any form of violence to any person just because they are from another gender. And therefore, when you commit an offense in response to gender-based violence, that is a mitigating factor. As you've seen in court, we've seen a lot of cases like that where the courts have said the defense of a battered woman is a very strong defense in law, and a defense that can actually eliminate liability, so that if the woman comes and say, I committed this offense because this man was always assaulting me, then of course the court will uphold that, and then she will be dissolved from liability. So please, always at all times avoid violence in any nature or form, whether virtual, physical, oral, whatever, written, any form of violence, avoid. Okay. And then number 10 is pleading guilty at the earliest opportunity. Don't waste the court's time. Don't waste our time. Just say you're guilty if you know you're guilty. If you do that, then the court will be lenient on you because you've not wasted the court's time. If you don't waste the court's time, then the court will be very lenient on you. Are we together? So that is the question when it comes to when it comes to mitigating and aggravating. So those are the aggravating factors and mitigating factors. The next thing that I want us to talk about is the question of participation of victims that I already mentioned in the previous class. I won't go deep into it. I've talked about the case of Lindex Waswa, of course, where I said that we need to understand two things: the participation of the victims' advocates during the trial process. Number two, we need to understand the participation of victims during sentencing. Now, there are various instances. Actually, the three main instances where the victim will be participating actively. The first one is the question to do with bail. So anytime before the court can issue bail, anytime before bail can be issued, then the victim's opinion must be sought. Okay. And then we have the question of plea bargain. Anytime you are taking out a plea bargain, the court must ask the victims what their opinions are. Then we have the trial process. During the trial process, the victims must also participate, either by appointing directly through appointment of their advocate, and then filing documents, asking questions, cross-examination, examination in chief. Of course, you know the limitation under Joseph Lindex Waswa that we went through in this very class. So they participate during the trial process, and then if they appoint an advocate, that advocate is called an advocate watching brief. The fourth instance where a victim must always participate is the question of sentences. So if you are getting sentenced, the victim must come and say, do you forgive this person? Have you guys forgiven this person? Or what is your opinion? So the victims will participate. How do they participate? By filing what we call the victim impact assessment or victim impact statement. So the victim impact statements will come from the victim impact assessment. So what is this? What is the victim impact assessment? Now, the victim impact assessment is the assessment of the impact that that offense has had on the victims. This commission of assault, what is the impact? This person assaulted you. How has that impacted your life? Maybe you are no longer working now, you can't see anymore, you can't walk anymore, your life has been disturbed and all that. So that is the impact. Or if it was, let's say, manslaughter or murder, that the person that was killed was the sole breadwinner of the family. Now, because they died, the family is now, that is the victim, the primary victim, as defined under 129, 139 actually, is no longer able to sustain themselves, and therefore they are suffering. So that is an impact. Okay, an impact could be a psychological impact, that after the commission of offense, say it is a sexual offense, then it has impacted you or affected you psychologically. You no longer feel confident, don't go out with friends, you don't interact with people. That is an impact. So the responsible, if it's children's officer or any officer appointed by the court, will conduct what we call the victim impact assessment, and then they will file their victim impact statements. So the victim impact statements are now the statements that will indicate the impact of that offense on the victim. Okay, it will first indicate who the victims are, the identity of the victims, and then it will outline the impact of that offense on the victim. And it will contain, like I've said, the first thing is the identity of the victims, and then the impact. On the impact, first thing is physical impact, emotional impact, psychological impact, financial impact, and then social impact and all that. So that will be part of that statement. And then the court will go and consider that and look into that as they pass their sentence. Okay, as they pass their sentence. Also, in the same statement, you'll find that the victim, that the accused person or the convicted person has been threatening the victims as well. So that will be put in the statement, and that will form part of the aggravating factors that this person is actually still threatening the victims. So that is the victim impact statements and assessment, and the role of victims when it comes to the criminal process. Also, don't forget the Victims Protections Act. The Victim Protections Act under Section 4, Section 9, 21, 26. Those 4 sections, make sure you read them to understand the rights of victims and the protection of victims. First, security and the protection, confidentiality and privacy. Okay, and then their normal rights includes all the rights under Article 50, the right to be given, all the rights of fair trial. They need to be given information regarding the charge. They need to be given opportunity to ask questions, prepare for defense. Prepare for a questioning, adduce their evidence, appoint an advocate, attend trial, the trial to proceed, and end without undue delay. All those rights that are given to the accused person are also rights of the victim. Okay, you just modify so that you understand better. So that is the participation of victims. Lastly, I want to talk about the question to do with the special people, the sentencing of the special category of people. Number 1, children. Sentencing of children. So children, at any specific point, a child is any person that is below the age of 18. That is a child. That is what the law defines a child to be. Okay? A child. Do not commit an offense against a child. Do not commit an offense against a child. If you commit an offense against a child, and I think even the prison system, they have such punishment in prison. If you go to prisons, there are people specifically that commit offenses against children and women. They have there's a way they're treated. So it is don't commit an offense against a child. All right. So assume that the child is the one committing the offense. What do you do? So in terms of children, in terms of sentencing of children, that things you need to understand. The first thing is that when sentencing a child, the court cannot convict a child. Let's come back. Let's not go to sentence. Let's come back to conviction. So the court cannot convict a child. What I mean is that the court cannot say that the child is convicted. The court cannot say that the child is convicted. No. Are you together? The court can't say that the child has been convicted. No. The court will say the child has been found to be in conflict with the law. So don't say that MNO, being the name of the initial name of the initials of the child's name, MNO has been convicted of this. If you're writing a ruling, if you're writing a judgment where the person there is a child, the accused person is a child, don't say the accused person has been convicted. No, you don't convict a child. Okay? The child, in terms of children, we say they have been found to be in conflict with the law. That is the first one. The second thing, you don't say a child has been sentenced to. Okay, you don't say a child has been sentenced to. Are you together? What do you say? You say that the court has made a consequent order of this. Could be a fine, could be a rehabilitation center, or could be a postal institution. So in terms of sentencing, you say the court has made a consequent. So the first order is the child is in conflict with the law. What is the second order? The second order is the court makes a consequent order as to what? Number 1, could be a fine, could be a custodial sentence of rehabilitation center, or it could be a postal institution. That is the second thing. The third thing is that children cannot be sentenced to death. children cannot be sentenced to death. If you see an instance where a child has been sentenced to death, that is a candidate. That is a candidate for appeal, revision. But most so revision, because revision is quicker. Okay, that is a candidate for revision or appeal. And if you are asking yourself what is all the difference, there is no difference between revision and appeals. I will explain when I get to revision. There's no difference between revision and appeals. Everything that can be appealed can be revised. Okay, it is only that one is done through an application and another one is done through a pleading. Okay, appeals, petition of appeal, and then revision, notice of motion. That is the only difference. But every ground of revision is the same ground of appeal. I will explain further on how to handle questions on appeals and revision. For now, just know that children cannot be sentenced to death. That is the third thing. The fourth thing, children cannot be sentenced to life imprisonment. Children cannot be sentenced to life imprisonment. That is the fourth thing. Children cannot be sentenced to life imprisonment. You can't sentence a child to a life imprisonment. That cannot change. The fifth thing is that children cannot be sent to adult prisons. Children cannot be sent to adult prison. For instance, you cannot send a child to Kodiaga, Kamiti in Naivasha. You can't send a child to an adult prison. Okay, children must only be held at the children institution, which are to any child above the age of 15, you go to postal institution. So a child, if the question tells you that this child is 17 years, then one of the available sentences is a custodial sentence to the postal institutions. Okay, number two, any child that is below the age of 15, of course, they go to rehabilitation center. So below 15, rehabilitation center. Above 15, that is 15 and above, postal institutions. 15 and above, postal institutions. Below 15 is rehabilitation centers. Okay, that is the fifth thing. The sixth thing about children is that children are not supposed to be sentenced to a custodial sentence if there's an option of a non-custodial sentence. So if the question says that if you commit the offense of stealing, you shall be sentenced to maybe 200,000, a fine of 200,000, or a prison term of this, you cannot give the child the prison term. If there's an option of a custodial and non-custodial sentence, you give the child a non-custodial sentence, which is either postal or rehabilitation sentence. Okay, so that is the question to do with children. That is any person that is below the age of 15. Sorry, any person that is below the age of 18. That is a child. A child is a person that is below the age of 18. The age of consent as well is 18. Age of consent 18. Age of a child 18. Okay. In other countries, age of consent is as low as 13, but a child could be 16. So it depends. But in our jurisdiction, any person that doesn't have an ID, ukiongea na yeye na hana ID, hajauma ID kwa meno, my friend, think about your life in committee. You'll go there and write a book, my life in committee. So any person without an ID, hata kama ni waiting, here there's something called waiting. There's nothing like waiting. You're the one who will be waiting in prison or committee. So don't do that. Run away. A child is any person below the age of, below the age of 18. And in that instance, we're looking at the legal age as evidenced by either the passport or the ID. They could be as old as anything. And they're saying that their face can be saying they are 80, but the actual age is 18. So ID is the conclusive evidence of age 18. So any person that is below the age of 18 is treated by the law as a child, And we have a specific court called the Children's Court that we shall be discussing when we get to the specialized course. That is our last topic. Okay, that is dealing with children. Also, we've had cases in terms of sentencing of expectant mothers, women that are expecting, women that are expecting to give birth. Now, there's a little bit of there's really no attention. The policy guidelines have given some directions in terms of women with, of course, they cannot be sentenced to death. A woman that is expecting, you can't sentence them to death. And then, of course, the court is supposed to take into consideration the mental health of this lady, as well as the safety of the child. So if they're going to, if there's an alternative of non-custodial, then they should get non-custodial. But even where they go to prison, the court must make sure that where they're going, there is what we call the best interest principle of the child. So you can go and give birth in prison. Of course, there's so many women that are given birth in prison. There's so many people that are given birth to in prison, and it is life. Being pregnant doesn't mean you're not going to prison. You shall go to prison, but the court is supposed to make sure that you, where you are going, it is not like the maximum. Again, it's different. I don't think women have the maximum prisons for them. I don't think there's any maximum prison for women. I think the worst could be Langata. So the court is supposed to ensure that even where you're being sent, the prison you're being sent, the court must also consider the best interest principle of your unborn baby to make sure that as they grow up, there is every facility available at their disposal for purposes of ensuring their livelihood and also their interest. So women that are expecting are not supposed to be sentenced to death. They will not be sentenced to death. That is the law. And of course, Article 53 in terms of the best interest principle of the child. And if there's a possibility of any non-custodial sentence, they need to get a non-custodial sentence. That is that. So as well as the senior members of the society, that is, I don't know when exactly senior, maybe people that are senior in this class, or people that have experience, or people that have worked with the welfare societies. At what age do you consider somebody to be a member of the senior society? Is it 70 years? Is it 80? Is it 90? Is it 90? 90 is we have very few people that are 90 in Kenya. Very few people are 90 years. Our life expectancy doesn't get there. But people that have worked with the senior members of the society, what is the max? What is the minimum?
Around 75, sir.
75. Yeah, and of course we can draw from there's usually this project where they give wazee money. This pesa ya wazee, you get it when you're 75. I think 70 or 75, around there. So when you get to that age, then you automatically graduate to become a senior member of the society. When you become a senior member, then of course there's a way you're supposed to be treated. But also those senior members sometimes are very, very dangerous, extremely dangerous to the society, But of course, some of you have interacted with senior members of the society. So sometimes let me just laugh. Hii ni maajabu sana. But anyway, senior members of society, any person that is within that age bracket, I think the government has, I will try and look up and see what age is considered senior, so that we are in the know. But they are supposed to be treated with some kind of preference in terms of they don't get death penalty. They usually could get death penalty in certain cases. These people sometimes commit very, very serious offenses. Very, very serious offenses. More so if we find somebody that is the age of 80, in the 80s or 90s, they are still defiling kids that are below 15 or 12, it's very crazy. In that instance, the court will just send you to prison to go and die there. We've had instances like that. But of course, also you consider that when you get to a certain age, even your nuts will start getting loose, and therefore you don't reason, and therefore that could be a defense in court. And the courts, we have instances where the courts have considered the fact that this person is not even reasoning, is not even reasoning appropriately. I've had that instance where one of the accused people, one time I was in court, then this person assaulted somebody to the point where this person almost died, and then he was called to explain. He wasn't even represented. By the way he was explaining and laughing how he was assaulting this person, the court was like, this person is not all, this person is not all, is not 100. So sometimes the court also understand that when you get to a certain age and time, then your mental capacity or the ability to do certain things reduces, and therefore that could be a defense. And that is why women that have, sorry, not women, but members of the senior society always get some preferential treatments. Okay. Lastly is persons with disability. Of course, persons with disability, there's no preference in terms of you could get a death penalty as a person with disability. But of course, the law is the Disability Act 203 is supposed to ensure, the court is supposed to ensure that you get the necessary assistance. You get the necessary assistance with regards to the level of disability that you have, or the nature of your disability. So that is that. Also, they're supposed to get non-custodial if that is an option. Okay. But the other things, they will still get death penalties, life imprisonment, and all that. I'm not very sure whether there is a specific prison for people with disability. I'm not very sure. But if you have interacted with such holding centers or prisons, you could explain or tell us whether there's a specific space where we hold people with disability. But of course, it's different because now there's the various nature. This disability is diverse. That is what I'm saying. So that is the question of sentences. That is the question of sentences. The court will pass a sentence, and then you will proceed and go and serve your sentence. Now, if it is custodial, you go to prison and serve your jail term. And then if it is non-custodial, you do exactly as you've been told. Could be a fine, community service, supervision, and all that. So that is sentences. That is sentences. Please make sure you are in the know when it comes to sentences. Okay, now I can unfreeze. I can lift the conservatory order that I've given earlier. Any question? Any question as we proceed into revision? Remedies against sentence. Yes, Ngeno.
A question that clashes on 2 points of aggravation and mitigation. In the event of, and this is a live case, in the event of a woman who kills a mad person for the reasons that the mentally challenged raped her daughter on 2 different occasions, and now this will be sort of a battered woman because she was trying to protect her child. Now, we'll see, can such persons be sentenced to maybe a day in prison as well?
Yes. If you're a mad person, why are you raping someone? Just stay mad. Pick a struggle. You can't say that you are committing a sexual offense and then when you're caught, you're saying I'm mad. You go to committee, my friend, for a long time. You'll be mad there until you become sane. Okay? So, still, remember, and this is one thing you need to understand. The law has made it very specific, and you could sample a lot of judgments in this end, that you are allowed to commit a crime to avert the commission of a gender-based violence or a sexual offense. Okay? If your child is being assaulted sexually and you commit a crime to avert that or to prevent that, yes, of course, you are not going anywhere. The court will protect you and the law will protect you. There's so many cases on that. Okay? And you cannot raise the question of insanity, that I was insane when I was committing this offense. No, no, no. The fact that you are committing an offense at that specific moment, and this offense is gender-based violence and also a sexual violence or a sexual offense in that nature, you cannot say I was mad. Yes, there's insanity, but to what extent do you become insane, but you're still able to form some kind of carnal knowledge on various occasions, like you say? So yes, you will not go to prison as the mother that has protected their daughter from that person. And of course, you don't need to be sentenced to any custodial sentence. You don't have to. So yes, you will go to jail, because sometimes people take advantage. They claim that they are insane, but even in that insanity, they're still able to commit those crimes, and then they run away and say, oh, I was insane. No, you go to jail, you go to prison, and then you learn the lesson. Are we together?
Thank you, Mwalimu.
Any other question? No question. So are we okay on sentences?
Yes, sir.
All right, so I don't see any hand up, so I'm going to assume that we are all together. So we have something called, so after sentences, we normally have what we're calling remedies against sentences. The same way in civil, we have remedies against judgment. So here also we have remedies against judgment and sentence. So if you've been sentenced to those number of years in prison, okay, what are your remedies? What are your remedies? What are your remedies? What can you do? Do you just go to prison and say, okay, let me go and serve my time in prison, become a pastor, and come out? You know, because that is the easiest way they use and say, okay, you just go to jail, you become a pastor in prison, and then you come out, or you become a gospel singer, and then you come out. Okay, so what are your remedies as an accused person who has been convicted and sentenced? The first one is the question of revision. The second one is the question of appeals. And the third one is a question of retrial. Okay? Now, three things: 2 applications, 1 pleading. Okay? 2 applications, 1 pleading. First one is revision. The second one is appeals. The third one is a retrial. Retrial is the last. And I will explain why retrial is the last. Now, let us get into revision and look at the history of revision. Now, previously in this class, some few minutes ago, I've just said that revision and appeals are the same thing. They do the same thing. Literally, they do the same thing. Same grounds, same prayer, same grounds. So why is there a difference? Okay, let us go to the history of the High Court so that we know why revision is there and why revision is running concurrently with appeals. So we used to have the Brits. Those are the white judges that used to sit in the High Court. And then we used to have the district magistrates. These were chiefs that were very collaborative with the government, okay, of the day, of course, the colonial government. So the colonial government appointed certain chiefs or certain community leaders to become magistrates. They were not lawyers, okay? They did not go to law school. They were called district magistrates, okay? And then from the district magistrates, we went to now the ordinary magistrates that we have now, and then the High Court. So district magistrates used to appeal to the chief magistrate If you had a matter in the district magistrate, you appeal to the chief magistrate, and then from the chief magistrate, you appeal to the High Court. Now, because there used to be that aspect of the white judges in the High Court and the African magistrates in the magistrate court and in the district courts, something happened. The first thing that happened is that they needed to create a supervisory power by the white judges over the African magistrates. And therefore, they created the power of revision. Okay? And they said that at any time, this judge could be sitting in his house, this white judge could be sitting in his house, and then they see news that a magistrate has made an order. Then tomorrow morning, they will call that magistrate and tell the magistrate, bring that file to me so that I can correct whatever you've done. That was a power of revision. It was given expressly to the white judges to try and supervise the African magistrates that used to sit both in the magistrate court and in the district court, the district magistrate court, so as to make sure that the decisions that were making were within what they considered lawful or regular or legal. Okay. The second thing they did is that they limited their jurisdiction. They limited the jurisdiction of magistrate courts. More so specifically in criminal, they say that murder can only be tried in the High Court. Murder could only be tried in the High Court before the white judges. Treason could only be tried in the High Court. Okay, treason could only be tried in the High Court. Okay, now you remember that most of the time when this in 1963, when we were coming up with the penal code, the number of people that were getting murdered or killed were the Africans. So because they were being killed by the whites, of course, they were being killed by the whites, and because we needed to protect the integrity and the rights of these white people, so the whites needed to take jurisdiction on murder issues. So it was only the High Court, the white judges, that would entertain questions to do with murder. So they retained murder, they retained treason and all that. Okay, what was the interest on treason? You know what treason is. Okay, so also treason was taken. So those two specific offenses domestically, they can only go to the High Court, or they could only go to the High Court. Okay, number three, they also changed and interfered with or structured a different way of approaching the High Court. Okay, so in criminal matters, when you're going to the district magistrates or you're going to the chief magistrate, the magistrate court, then you go through a charge sheet, a normal charge sheet. But when it comes to going to the High Court during that period of time, they said you needed an information whereby you go and inform. Okay, you go and inform the High Court, and that is where we came with the information and the charge sheet. So those are the kind of things that used to happen, that even after the leaving or the exit of these folks, we are still stuck with those things. Okay, we are still stuck with murder at the High Court, treason at the High Court. We are still stuck with revision. We are still stuck with information and charge sheets. Okay, we are still stuck with them. So that explains why we have two competing remedies. That is the remedy of appeal and the remedy of revision. Because you'll be wondering, when do I revise and when do I appeal? Okay, so remember, every ground of revision is every ground of appeal. So anything can be revised or anything can be appealed. That is the first thing. The next thing is that the revision is only a power of the High Court. It is a supervisory jurisdiction of the High Court. And I've said this before, that if you are the High Court exercising a supervisory power, then you supervise those that are below you. And therefore, that power of supervision, the power of revision, can only be applicable over the decisions of magistrates or any court that is below the High Court. Okay.
sir.
Yes.
So that therefore means that if you are told, let me give you an example. James was charged with the offense of robbery with violence. Okay. James has been sentenced to death. James argues that he was not given an opportunity to cross-examine. James argues that trial was conducted in English, whereby he could not understand what was going on. He wasn't given an advocate. James comes to you and is asking you to advise on how to secure his rights in that case. What do you do? Somebody? Yes, Kamiri John.
Yes, you can either apply for an appeal or you can apply to the High Court for a revision.
Yes, that is okay. Next example, James has been charged with the offense of murder. James has been sentenced to death. James has the same complaints that the trial was conducted in English. He wasn't understanding English. He wasn't given an advocate. Neither was he given a charge sheet. He has been sentenced, convicted of murder, and sentenced to death. He has come to you and is asking you to help him on how to proceed. What do you do? What are your options? Number one, someone, Alingo.
Mwalimu, number one, he can appeal to the Court of Appeal because the first trial court was the High Court, so he has that remedy to appeal to the Court of Appeal.
Number two, Alingo. Number two,
A trial, Mwalimu, although I'm not so sure, I still stand guided. He can make an application to review in the same court, the High Court, on the decision that was made regarding the sentence that imposed on him.
okay. So first things first, when the decision in question is a decision of the High Court, there is no revision. Okay. When the decision in question is a decision of the High Court, there is no revision. Okay. That is number one. Number two, and just clearing the air so that we are clear on the same page. In criminal, we don't have an application called an application for review. Okay. The only application we have is an application for revision. However, revision can also be termed as review. The effect of revision is that the High Court can review the decision of the magistrates. Okay, now that is only a power of the High Court that is done through review. Now, the term review is used in its ordinary English meaning. Okay, ordinary English meaning. Are you together? So review is used in its ordinary English meaning. So in civil, review is not used in its ordinary English meaning in civil. In criminal, the word review is used in its ordinary English meaning, which means just reviewing in the ordinary sense of it. Okay, reviewing in the ordinary sense of it. Okay, that is something that we both need to understand. So that if you are making an application for revision, that is where you'll be using the term review. But essentially, you don't have an independent application called an application for review. And that is what you need to understand. So we don't have the review in civil where you apply to the same court. No, that is not available in criminal. In criminal, there are only 3 options available. The first option is revision, which sometimes some texts will call it review. It is revision to review. Okay, so your prayer 1 in that revision application could be the court be pleased to review the decision of the magistrate, altering this and changing it with this. That is when you find that aspect of reviewing which is being used in its ordinary English meaning. Okay, the second option is appeal. You can appeal and then retrial. There is no review where you go back to the same court. That is not available in criminal. It is only available in civil. So there are only those 3 things. That is why I'm saying, if you see a question telling you that judgment was passed or a sentence has been passed, there are only 3 things you need to do there. If you're supposed to draft anything, you draft a revision, appeals, or retrial. So when do you draft revision? When do you draft appeal? When do you draft a retrial? Okay, the first one is that both revision and retrial are applications. So if the question says proceed and draft the application, then it is either the application for retrial or application for review. There is no appeal. If the question says proceed and draft a pleading, there is no review. Sorry, there's no revision. There is no retrial. It is appeal. Are you together? So this is very simple. It doesn't confuse as it confuses in civil. So we will get there. So revision is only a power of the High Court to review decisions of the lower courts. Are we together? That is revision. That therefore means that if it is a decision of the High Court, then you only have 2 choices. The first choice is appeal. The second choice is retrial. Okay? If you're told to prepare a pleading, appeal, application, retrial. But I will explain, because revision is not available at the High Court level, because it is a supervisory jurisdiction of the High Court to the courts that are lower than the High Court. That is clear. Are we together?
Yes, Mwalimu.
All right. Now,
Yes, sir.
let us read 362. Somebody read for us 362. Quickly, somebody just unmute and read.
362, power of the High Court to call for records. That's on revision, yeah? The title is revision. The High Court may call and examine records of any criminal proceedings before any subordinate court for the purpose of satisfying itself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and as to the legality of any proceeding of any such subordinate court.
Mwalimu, you are muted.
Oh, sorry. I was saying that when it comes to the power of revision, the High Court may call for and examine any record in any criminal proceedings before any subordinate court. And we said that there used to be 2 subordinate courts, and now there used to be a lot of subordinate courts actually, but there used to be 2 main ones. Right now we have quite a number of subordinate courts. Which is the first subordinate court? Number 1. Somebody tell me, what is the first subordinate court?
Magistrate courts.
Chief Magistrate Court.
Number 2?
Senior
Court
Principal
tribunal.
Magistrate Court.
Abdisalan, what are you saying?
Senior Principal Magistrate Court. The Principal Magistrate Court.
That is all magistrate court. That is 1. Number 2?
Or the Cadiz Court.
We don't have Cadiz court in criminal.
Then the court martial.
The court martial. Somebody else? The children's court. And of course, we have the anti-corruption court, the county court, the municipal courts. Those are subordinate courts. Okay, so we don't say, subordinate doesn't mean now just magistrate. No, magistrate is part of the subordinate courts. All right. So the court can call for a file. The court can call for a file at any specific time, and examine the records for purposes of satisfying itself as to, number 1, the correctness, legality, and propriety, and lastly, regularity. Okay? Now, what is correctness? What is correctness? What is legality? What is propriety, or what is regularity? Everything. For instance, if the court refuses to give you an opportunity to cross-examine, that is incorrect, that is illegal, that is improper, and that is irregular. So there's no specific thing that we can point and say, this is improper, this is illegal. No. Anything that doesn't adhere to the rules provided for in law, whether the Constitution or the CPC or the Evidence Act or whichever act, that will form part of incorrect, illegal, improper, or irregular. Okay, so sometimes you'll be asking yourself, so which of these specific orders will fall under this so that I know what to apply for revision for? No, it is any order. So any mistake that has been done by a magistrate will be termed as incorrect, illegal, improper, or irregular. Now, in certain instances, certain questions like 2017 question 5 or question 4, 2017, 2018, 2 questions. There's a question around number 5 or 4. Somebody can get it. If you get it right now, bring it, I'll project it. Where you're being told, and there's also a question in the 20 series. When I mean the 20 series, that is the listed series. If you look at the setting of these exams, from 2011 all the way to 2019, it is one type of setting. And then there's this 20 series, which is the current series, which is from 2021, 2022, 23, and 24. There's a different mode of setting. So there's a paper also in the 20 series that has a question on the correctness or legality. So you get a question where the examiner has clearly told you that your client is seeking to correct the correctness, legality. I know you know that question. Please send it my way right now so that I can project it. Let me see if you have sent it. If you have, you tell me. So there's a question like that. So sometimes the examiner will give you the words already. When you see those words, then you know it is a question on revision. Okay, so that is what revision is. So how do you approach the court for orders of revision? I've said revision is a power of the High Court to call for a file before any magistrate or any subordinate court and relook at that file and review the orders that have been given. So let me give you examples. For instance, let's start with the basic one, bail. You don't appeal. Or let me say it this way. In criminal, we don't have interlocutory appeals. For instance, in civil, there's a hearing going on for the conservatory orders against the impeachment of for instance, Rigathi. Now, if the High Court has refused to lift, okay, the respondents have filed an application to lift the conservatory orders. If the High Court tomorrow refuses to lift that conservatory order, then the respondents can appeal against that ruling to the Court of Appeal. Okay? Now, in criminal, there is no interlocutory appeal. It means if you file an application in a criminal court, okay, and the court has refused to grant your prayers, that is the end of it. You can't appeal. Okay? The only thing you can do is you can apply for revision if it is a decision of the magistrate. Okay? So please make sure you understand that. Make sure you understand that bit very clearly. Okay? And what am I saying? What I'm saying is this. The first instance where you're going to use revision at any time is where there is an application that has been filed within the process. So any decision on an application, any ruling that has been made in the criminal process, you challenge that ruling through a revision. You've applied for bail, you've been denied. You go and revise in the High Court. You've applied to adduce evidence or to call a witness or to question something or to, you've made an application, the court has rejected. You've made an application to adjourn or to call somebody that is also look at some documents. They have refused to give you those documents. You go to the High Court to revise. So revision is a way of correcting the interlocutory appeals. Okay? That is the first one. The second instance is that everything that is a mistake that can be appealed can be reviewed. Can be revised. Okay? Now, how do you approach the court for orders of revision? How do you approach the court for orders of revision? There is a paper called in the 20 series 2020, 2022, 2022, yes, 2022. Wait, is it true? Yes, 2022, question 1. Question on revision, 2022, question 1. The question on revision. We look at that paper so that we are all on the same page in terms of how to approach questions on revisions. There's so many, but we look at that paper first so that you can understand what I'm talking about. All right, so I've said, how do you approach the court for orders of revision? So you've been told, in practice, you can even send a text message to the judge. Okay? In practice, you can even send a text message. You can send an email to the judge. You can do anything. You can call a judge. You can walk to the judge's chamber. You can do a press conference and the judge will see and the judge will do revision. That is in practice. You can write a letter to the judge. Now, when it comes to exams, you can't do that. You only need to make a formal application, which in this case is a notice of motion and a supporting affidavit. And remember that all applications in criminal are notices of motion, except one specific application, or really two, but really one, which is habeas corpus. Okay, habeas corpus. And of course, instances of judicial review, you will have chamber summon as well. And the notice of motion, depending on what stage you are talking about. So all applications, all the remaining applications are notice of motion. So you do a notice of motion and you pray for an order. So for you to clearly get an order of revision, you must know exactly what you want to correct. Because remember, a revisionary order is supposed to correct something. It corrects a position taken by the magistrate, okay? And then it replaces it with something. So let's take, for example, you have been denied bail. Okay? You have been denied bail. So how do you make that application to the High Court in the instance where you've been denied bail? So what is your first prayer? That the court be pleased to review and set aside the order of the magistrate denying the applicant bail pending trial. Okay? Number 2, now you pray for what you want. Okay. Now remember, the court has made an order. So the first thing when you make an application for revision, you first set aside that order and then you pray for what you want. Whatever you are denied down there, you now ask for it up here. So bail, okay, you're denied bail. What are you praying for now? That the court do review or revise and set aside the decision of the magistrate or the order of the magistrate or the ruling of the magistrate denying the accused person bail pending trial. The first prayer. The second prayer is always, at all times, what do you want now? That is why you are saying the court do admit the accused person to bail pending trial on reasonable terms. Okay? On reasonable terms. Okay? So that is exactly what we're saying. So assuming that your client has been given bail and bail has been set at 1 billion. So how do you proceed? The first thing, you need to set aside the bail orders of 1 billion. So the court be placed to review or to revise. I've said those two words can be used interchangeably when you make an application for revision. So the court be placed to review or to revise the bail terms, okay, issued by the magistrate court. And then what are you praying for? Number two, the court do admit the accused person to bail pending
on reasonable terms.
During a trial on reasonable terms. So guys, this is a conversation. So you will say, oh, that person has done this and this and this and this to me, and I'm not happy. Okay, fine. So what do you want me to do? First, you want me to set aside what they have done to you. Number two, tell me what you want now. Are we together? So the things that you prayed for there are the things you're going to pray for here. Okay. So what are some of the powers? Okay, what are some of the powers of the High Court during revision? Time is up. What are some of the powers of the High Court during revision? So the first power, let's go to section 354. 354. Okay, so powers of the High Court during appeal. Let's go back to 364 so that we can go back to 350, 360. Let's go back to 362 and then 360, 364. Are you together? In the case of a proceeding in a subordinate court, the record of which has been called or which has been reported for orders or which otherwise comes to its knowledge, the High Court may, remember, the High Court may, in the case of a conviction, exercise any of the powers conferred on it as a court of appeal under section 354, 357, and 358 or the question of appeal. Let's go. Here, so to conclude the point that the powers of, appeal and revision are the same thing in terms of their substantive nature, the powers of the High Court during appeal are the same powers of the High Court during revision. Whatever they can do on appeal are the same things they can do on revision. Okay? They may, number one, reverse the finding or sentence, acquit or discharge, alter the finding, maintain the sentence, reduce or increase the sentence. So essentially, what I'm saying is that the powers of the court during revision would include reversing the order, altering the order, or making another order. So anything, the High Court has unfettered jurisdiction. They can do anything regarding that case at any time. So you pray for anything that you want. This is the only time you will pray for anything that you want, and the High Court will consider it and give it to you or reject it. Okay, So I've said, if the trial was conducted, for instance, if the trial was conducted, like the paper that I've told somebody to send me, somebody has sent it to me. Let me see if it is that one. No, that is a question 6. The question 6 is on the trial, Ms. Avora. That is question 6. The question I'm looking for is a question 5 or a question 4. All right, so I was saying that, for instance, assume that I'm trying to make you understand how to draft your orders. We will draft them, of course, don't worry. But you need to understand the theoretical aspect of it first. So assuming that your client has been convicted, okay? Your client has been convicted, they have been sentenced to 10 years in prison, and they're telling you that they did not understand the language of the court, the trial was conducted in English, they could not understand the language of the court, or they were denied the right to cross-examine and all that. How do you proceed from there? How do you proceed from there? What are you supposed to do? So when you apply for revision, what are you going to be praying for? Okay. Now, you want the court, number one, the court be pleased, number one, to set aside the sentence, not the sentence, it starts with the conviction. The court be pleased to set aside the conviction. Number two, set aside the sentence. Guys, there are two things. There are usually two orders. The first order is on a conviction. Okay? The first order is on a conviction. Quash the conviction, set aside the sentence. So they're coming into two. When somebody has been sentenced, it means they were convicted. So you don't challenge the sentence alone. You challenge the conviction also as well. Okay? If you challenge the conviction, guys, I want us to be very critical. If you challenge the conviction, it means you are also challenging the sentence. But sometimes you can challenge the sentence without challenging the conviction. For instance, when you plead guilty, you can't challenge the conviction, but you're challenging the sentence. I'm feeling like I'm confusing you guys. I'm just having this kind of feeling that I'm really confusing someone here.
Not really.
You are very okay.
It's very clear, William.
Okay, so why am I saying that when you challenge a sentence, when you challenge a conviction, you're challenging also a sentence? The reason is very simple. If you are asking the court to quash your conviction, it means you want the court to find you not guilty. And if you're found not guilty, then it means even the sentence is not proper now because you're no longer guilty. Okay? On the inverse of it, you could challenge the sentence alone by saying, I don't challenge my conviction. I'm guilty, yes. So I don't challenge the conviction. But you sentence me to death. In a case where I stole the chicken, I pleaded guilty for stealing the chicken, yes. So I'm not challenging my conviction, but the sentence is illegal. So you can challenge the sentence alone, or you can challenge the conviction and the sentence. Okay, so you have to be very clear. What are you challenging in that instance? So if you're challenging both, your first prayer is that the court do issue an order setting aside the sentence, quashing the conviction, and then number two, setting aside the sentence. Okay. Number three, what do you want after that? What do you want after that? Could be a retrial. You could be praying for a retrial, a new trial, that the court do issue an order that the matter be tried afresh, or you want the court to direct that matter be tried before another magistrate. Okay, so another bench. You get what I'm saying? So that can happen. So set aside, and then tell the court what you want. So maybe what you want is an acquittal. Okay, that your client be acquitted. So in this instance, you are claiming that you are wrongfully convicted. The court has the power during revision and during appeal to acquit you. You can see, reverse the finding or sentence and acquit or discharge the accused person. Okay, or order for him to be tried by a competent jurisdiction. Okay? I hope you are getting each other. Are we together?
Yes, sir, we are
Guys?
together, sir.
So based on that information that you now have in terms of revision, you will come here and ask the court, number one, to reverse the conviction, quash the conviction, which is called the finding. When you say alter the finding is, are you found guilty or are you found innocent? So alter the finding, which is the finding of guilt, conviction. Okay? In an appeal from a conviction. So the finding is the conviction. So you can be asking the court to quash the conviction. Number two, to set aside the sentence. Number three, to acquit or to discharge you. Number four, you could be asking the court to appoint a new bench, to order a new trial, or to order for a fresh, magistrate or bench of magistrates to handle the matter, or another jurisdiction. So it depends on what you want. What is your client saying? In some questions, your client will tell you, I am innocent. And therefore, when you go to court, you pray for an acquittal. That the court do acquit. Okay? Do acquit the applicant. In certain instances, your client will tell you, or the question will tell you directly, that no, I want a fair trial. I don't want to be acquitted. I want my matter to be tried fairly. So in that instance, you are praying, number one, that the conviction be quashed, the sentence be set aside, and then the court to order for a new trial. Because your client has told you, mimi nataka a new trial. This trial was not fair. I want another one. The question will tell you that specifically. Or the question will tell you, your client is claiming that he's innocent. So you ask the court to acquit your client. Guys, are we together in terms of, you need to understand what is this thing called revision? When we go to court, how do we go to court? What are we praying for? And why are we praying for them? Once you know that, you are able to put down on paper. That is why I'm spending so much time trying to explain to you what happens when you make an application for revision. So you make it to the High Court regarding a decision of the magistrate. What are you praying for? You look at the orders that the magistrate made. Now, if these orders were anything apart from acquittal, apart from conviction and sentence, then you could pray for the court to set aside the decision of, or the order of the magistrate dated that day. Guys, I've said there are various decisions that you can challenge on revision. For instance, it could be a ruling, bail rulings. It could be a ruling on the question of calling witnesses, production of documents, supply of documents. It could be a question on changing of plea. It could be anything within the interim process. And then lastly, it could be a question of conviction or sentence, the judgment of the sentence. All of them you can proceed and revise. So if you are revising the interim ones, the same thing, you ask the court to set aside the order dated this day, and then what? After setting aside, what do you want? You tell the court exactly what you want. You set aside, and then what? Okay? Unlike in civil, sometimes you can just set aside, and that is it. In criminal, you set aside and tell the court what next now. Okay? Bail, set aside the order of court denying bail, and then give my client bail. Okay? Your client has been denied the opportunity to adduce evidence. Okay? What are you praying for? Set aside the order denying my client to adduce evidence. Number two, what next now? Allow my client to adduce evidence. Okay? Your client has been denied the opportunity to cross-examine. Okay? Set aside that order and then ask the court to allow the court to direct that your client be given an opportunity to cross-examine. Your client has been convicted and sentenced. What do? Quash the conviction, set aside the conviction, and then what? What is your third prayer? Your third prayer is either new trial, the court to order for a new trial before a new magistrate, or the court to order a new trial in a different jurisdiction, or the court to acquit your client. Guys, so it is simple. What do you want the court to do? Okay, what is the next step? So what should the court revise? The court should revise this and then do this. Now, sometimes there are certain orders that will be made. There are more than one. You set them aside first. You revise all of them and set them aside first. And then you ask what you want. So if the court made five orders I don't like, the magistrate made 5 orders you don't like, the court do issue an order setting aside this order, setting aside this order, setting aside this order, setting aside this order. And then now you pray for what you want. The court to order that, the magistrate court to do this and this and this and this and this. Full stop. Guys, are we together in as far as the prayers are concerned?
Yes, we are together.
Grounds. So what are your
Yes, sir.
grounds? Your grounds will be the question. Grounds will always be in the question. What are the grounds? The grounds will be the question, where you'll be told was denied the right to cross-examine. So your grounds will be that the magistrate court denied the accused person the right to be cross-examined, which is his right under the Constitution. Full stop. Bail, that the magistrate issued bail on unreasonable terms, therefore denying the accused person the right to bail, which is the right under the Constitution. Same thing, they will be in the question. Their grounds will be in the question. You just need to know what are you praying for, know what you're challenging, and know what you want. That is all about revision. The only thing that is remaining on revision is now to look at the actual questions on revision, and then we make progress in terms of how those questions can be answered. I can see some people have sent me questions. Yes. That is October 2022, as well as April of 2022. Question 1. And then there's a question in the old series, that is 2019 before, 2019, 2017, those 2 papers, there's a question there that I want. Question 4 or 5. It talks about the question of legality, but there are so many questions, guys. Even in the last exams, there's a question there. I will bring it out and then we can, question 4, 2019. Let me check it out. Let me check this question 4, 2019. So guys, essentially we are done. We are actually done. I can take questions so that we can adjourn. July is the question on July is appeals. I will explain why it is an appeal. Let me look at the person that has sent me this question. Please resend it again. The person that has sent me November 2019 question, resend it again. I can download it. Nyang'ao, we start with you quickly.
William, I have a question, probably a clarification for you to, a question for you to clarify. You have said that revisions are in a solution to interlocutory applications, appeals rather, in criminal matters, and it vests a supervisory power on the High Court over inferior courts. What happens when you have an interlocutory appeal based on proceedings in the High Court?
But I've just explained that right now. I've said there's no interlocutory appeals when it comes to decisions of the High Court. You have to wait until the matter is done and you appeal. You can't appeal in the interim. There's no interlocutory appeal. What we're saying is that the criminal procedure cannot allow the way it was structured, you look at the Tom Chomonle case, the Lamere's case. The court said that the legal system in terms of criminal law does not allow for interlocutory appeals. If you have a question, you have to wait for it until they are done and then you appeal. And therefore, the only way you can address that is through revision. So if revision is not available, what do you have? Appeals only. So you wait until the matter is done, your client is convicted of murder or treason, and they are sentenced, and then you appeal. And in your appealing, you use the ground that you wanted to appeal in the interim as also a ground of appeal. Tuko sawa?
Yes.
Yes, there's no interlocutory appeals. If it is in the High Court, there are only two remedies, retrial or appeal. So for appeal, you have to wait until the case is done and then you appeal. But there's no, in civil, what I'm saying is in civil, guys, you can see, you can file an application, your prayers are rejected, you appeal the application again, until 5 years, you're still prosecuting the application. In criminal, it is not available. It is not allowed. You can't appeal on an application. So you wait until the case is done and then you appeal the whole case together. So because of that, it has been said that you have to, you can only use a revision. That is what I'm saying. Somebody has sent me a case. Question, yes, Kriga, proceed.
Good evening, Mwalimu. I could have asked this question earlier, but your instructions were particular that you are not going to entertain questions until you're done. It's about the sentencing guidelines on mitigation. Can mitigation be used against the convict in a subsequent appeal? Like, for instance, if they apologize or they confess at that particular point in time, because it seems to like some of the mitigation can amount to self-incrimination. Thank you.
So when you go and now when you're mitigating, it means you've accepted the offense. But in case you change your mind, it cannot be used against you. It cannot be used, anything you say as an accused person, unless you said it under oath, which is during your statement, when you're making your opening statement, making your statement on oath during the opening of the accused person's case. It will not be used against you. That's what I'm saying. So what you say during mitigation cannot be used against you when you appeal. Okay. I'm trying to did you get what I said?
Yes, Mwalimu. Whatever you say is not incriminating because it was not given under oath.
Yeah, it wasn't given, so they can't use it against you. Yeah, it is not considered as an admission. For it to be an admission, then it must be something that you said as per the rules provided for admission or confessions in the Evidence Act. Are we together? All right, sawa. Any other question? Ikesi, Christy? I'm trying to.
Okay, I saw this question. So because you're told that you can't appeal
on a conviction based on a guilty plea, what will happen in a situation where maybe the charges that were read to the accused were based on a defective charge, or maybe the plea taking process was not procedural? How would you go about it?
That is an exception to the rule. Okay, that is an exception to the rule. I'm trying to project something. I don't know whether it's coming on the screen. That is an exception to the rule. So you are not supposed to appeal. To appeal against a conviction when you pleaded guilty, except in certain instances. Number one is an instance where the court did not follow the rule in Arden versus Republic. I don't know whether you can see my screen, guys. The court did not follow the rule in Arden versus Republic when they were taking your plea, or you did not understand what you're pleading to. They never read it in the language you understand. You were just joking, and then they took it serious. You get what I'm saying? Cynthia, who is that? That's Cynthia. Guys, I know time is gone. I just wanted to highlight a question. I wanted to highlight a question, question 4. Question 4, somebody read it. That is 19, question 4. Somebody read it.
Boss was charged with the offense of stealing contrary to Section 261, read together with Section 268 of the Penal Code. During her trial, where she was acting in person, several issues surprised her. Whereas she had the original document she had stolen, the court relied on a photocopy which was not certified without following the laid down rule on production of copies. She was also not advised that upon the examination in chief by every witness, the court has a duty to inform her that she has the right to cross-examine the said witness. She also noticed that the proceedings were conducted in English, a language which she was not well versed with. She was never asked whether she understood the said language. She was also never given an opportunity to defend herself, as she was never asked whether she intended to call any witness, or otherwise, having been told by the court that she had a case to answer. She was eventually convicted and sentenced. She has approached you to assist her in correcting the entire trial, which according to her was illegal, improper, unprocedural, and incorrect, with a view of having a legal, proper, procedural, and correct trial to be conducted. Prepare the necessary application.
Yes, and somebody wrote petition of appeal. So you are very sure that it ended in supreme tears for that person that wrote that there, if that is exactly what they did. Okay? So this is not an appeal. This is not an appeal. Prepare the necessary application, notice of motion. Okay? The question has told you, she has approached you to assist her in correcting the entire trial, which according to her was the words that are used specifically under Section 362 on revision, the ones that I was highlighting: illegal, improper, unprocedural, and incorrect. That is what she's saying. Now, what is she looking for? With a view of having a legal, proper, procedural, and correct trial to be conducted. She wants another trial. So when you set aside this conviction and sentence, you pray for the court to order for another trial. That is what your client is looking for. Guys, you get what I'm saying? Notice of motion, supporting affidavit. Okay, in that notice of motion, you are praying for, number one, the court. Let's look at the conviction. So you're being told under the second last paragraph, she was eventually convicted and sentenced. So the court to revise and set aside the conviction, the court to set aside, the conviction and set aside the sentence. Number two, the court to order for a new trial. Could be before, and that is in your discretion to decide. But the court to order for a new procedural trial or a new trial to be conducted before, could be another bench or before another magistrate. It is you to decide. Okay, but what is she looking for? to set aside the conviction, to quash, conviction and the sentence, and also to have another trial. So you pray for that other trial. And then the grounds are paragraph 1 and paragraph 2, that the applicant was charged with the offense of that, contrary to that. Don't say that certain things surprised her. Don't say during a trial where she was actually acting in person, several things surprised her. Don't say that. You'll be the one who will be surprised. Don't say that. Don't copy paste everything. That's what I'm saying. Don't copy paste everything. So paragraph 1, you only say that the applicant. Don't even say boss. Just say the applicant was charged with the offense of stealing, contrary to section 261, as read together with 268 of the Penal Code. Okay. And then you proceed and write the second paragraph, that whereas she had an original document that she had stolen, the court relied on a photocopy which was not satisfied without following the laid down procedure on the production of copies. Okay. Next paragraph, you say she was also not advised that upon examination in chief by every witness, the court has a duty to inform her that she has the right to re-examine. Number 3, she also noticed that the proceedings were conducted in English, a language which she was not well versed with. And then lastly, she was never asked whether she understood the said language. Okay. And then, there's another ground. She was also never given an opportunity to defend herself, as she was never asked whether she intended to call any witness or otherwise have been told by the court that she had a case to answer. Okay. Full stop. She was eventually convicted and sentenced. That is your ground. 1, 2, 3. Okay. Drawn on file by to be served upon. 10 marks. Good. Supporting affidavit, you get it there. Guys, are we together? Are we together? Any question arising from this question? Time is very much gone and I want to release you guys because of time. Please, please, please. If there's no question, bring the question down and I stop the recording. Please, that is revision. Just there's nothing much about revision that we haven't talked about. So please, please stay within the line, read. In the next class, we talk about appeals and retrial and habeas corpus. We are moving very well. We just need one additional class. I will see when to give it, but I'm not sure. Maybe I just one free class one of these fine days so that we can cover something on criminal, but we are moving very well. We will soon start the past papers and see what the past papers have. But also we'll be looking at some past papers as we go so that we are on the same page. But I hope you at least know something about what we have discussed today. All right, guys, that is it for now. The recording has been stopped. Please ask for it now. Don't ask for the recording tomorrow. I don't understand the logic. I don't understand the logic why you ask for the